Mr. Quigley,
Yes.
I'll do
I have Mr. Travino,
first.
Your Honor.
Yep, it's 2408789 FH. People versus Daniel Travino II. Mr. Quigley's here on behalf of the defendant, and Ms. Brenner's here on behalf of the people.
Morning.
Good morning. And Mr. Quigley, apparently your client is not present.
That's correct, Your Honor. I did receive a voicemail on my phone this morning that he did not have transportation. He lives in Lansing. I think it was laudable of him to at least call and let me know that. Most of the clients don't show up, and that's that. He would very much appreciate an adjournment in this matter. He wants to take care of it. He just didn't have the ability today.
Ms. Brenner?
Your Honor, he does have an income withholding order in place. This is one of the cases where we're gonna place him on a delay of sentence. That's all we're gonna do today. I'll leave to the court's discretion if you wanna adjourn it or do a bench warrant.
So I did not have a delay of sentence for this particular defendant.
Those were my notes also, Your Honor.
So,
You don't have it?
well, I have the pre-sentence report, and I didn't go over whether anybody had any corrections or anything with the plea agreement on the pre-sentence report. Doesn't indicate a delay of sentence for this particular defendant. So, and I don't have independent recollection of
My notes
every-
indicate that I was gonna give him the break even though he hadn't paid the 25% because he had an income withholding order now. He pled guilty to count one, no upfront jail, must pay consistently and reduce to $4,800 for an attempt and down to 0 for a misdemeanor. That's what my notes indicate.
Yeah, mine say by sentencing, but it doesn't say delay.
Oh,
That's the difference. So, in my notes, I took notes from the pre-sentence report. When I get pre-sentence report, I don't go back and review every plea agreement, because that would take forever.
Yeah.
So I assume that it's on the pre-sentence report, or it would be brought to my attention prior to sentencing. So, what I'll do in light of all of that is I will adjourn to next week. So 3/19, just because, I'll need to check those notes, because I was prepared to sentence him today, and I'll need to fix that, so he lucked out on that one, because I
Thank
would
you
have
very
had to
much,
do that
Your Honor.
either way, so.
thank you, Your Honor.
Okay, thanks. And Ms. Vandenberg, are you ready on Cervantes? Okay, so this will be 2408841 FH, People versus Pablo Cervantes. Ms. Vandenberg's here on behalf of the defendant, and Ms. Brenner's here on behalf of the people. And sir, could you verify your date of birth, please?
2/21/1994.
Thank you. And I did review the pre-sentence report, and unlike the previous defendant, I do have a note that this defendant had an agreement to a delayed sentence. And so I've reviewed the pre-sentence report. I don't see any problem with moving forward in that way. Do you, Ms. Brenner?
No, Your Honor, I do not.
Ms. Vandenberg?
No, Your Honor, thank you.
Okay, so what I'll do is have Mr. Cervantes come back on November 19th, and that'll be at 9 a.m. for sentencing. So I'm delaying the sentence until that period of time.
And Your Honor, the plea agreement's just missing one little thing that we need to correct. It
Okay.
should say that he has to remain current each month during the delay. That was part of the plea agreement, and it's not listed on the first page of the plea agreement. But other than that, it's fine, Judge.
Okay.
That is correct, Your Honor.
And so you understand what that means, Mr. Cervantes, is if you're not current, then at any point, the prosecutor could request immediate sentencing, and that would happen as opposed to waiting until November.
Yes.
Okay? All right.
Thank you.
Thank you.
Thank you, Your Honor.
And is it Slojutro?
Yes, Your Honor.
You ready on Taylor?
I am, thank you.
Okay. So this will be 2408618 FH, People versus Joseph Lee Taylor. Mr. Zlotrou's here on behalf of the defendant, and Mr. Heckman is here on behalf of the people. Mr. Taylor here, sir, could you verify your date of birth, please?
5164.
Thank you. And Mr. Hagman, do you have any additions or corrections to make to the pre-sentence report?
I do not, Your Honor.
Do you?
Yes, Your Honor, I filed a correction last week as to the amount that's listed in the narrative, that lists, 1/4 of a gram. The lab report in this case indicates less than 1/10.09 grams.
And I did not get that.
Okay. I believe that was filed by my office on Thursday last week, Wednesday or Thursday.
Okay. And what page number?
I believe it's on the narrative page. I believe it's page 2 of the, narrative portion. I can get that.
You mean the description of the offense?
Correct.
Okay, and Mr. Heckman, you said you had no objection to changing that from .25 to .09?
That's correct, Judge. The 2.5 came from the weight with packaging. The lab clearly weighs it without packaging.
Right.
And it is a .09 once you input the lab.
Okay, all right, so I made that correction. Any
Thank you.
other corrections?
Nothing further, thank you.
All right, do you agree, Mr. Taylor?
Yes, yes, Your Honor.
And Mr. Heckman, did you have a statement on behalf of the people?
No, Your Honor.
And Mr. Zolutro?
Zolutro, thank you, Your Honor.
Zolutro.
Yes, I do. Mr. Taylor here, he has, I would ask the court to consider, he has been in for 210 days. He was originally arrested back in August of 2024. On the 14th of August, he does have medical conditions that he's been dealing with in the jail. He's got bone spurs in his lower lumbar back. He also has generated some liver conditions that he has a MRI currently getting set up for him while he's at the jail. He wonders if that might be some serious medical condition pending for him. Ultimately, Your Honor, this was considering less than 1/10 of a gram of methamphetamine. He has been very interested in treatment. He's been very open about his addiction with me. He would like treatment for that, and he is looking to do that once he's done with this case. Ultimately, Your Honor, this has been an eye-opening experience for him. I would just ask that the court consider the time he has served and leave the rest of the sentence to the court. Thank you.
So the PSI says 2 days.
Yes, that's correct.
Okay, but you just said
Yes, he's been in.
for something else.
Yes, Your Honor, there is a parole hold. I understand what that implies
I
for
understand. Oh,
everything,
that's
but-
why, okay.
Yes.
Okay. All right, thank you. And then, Mr. Taylor, did you have anything that you'd like to say before I sentence you?
I'd just like to say that I got a drug addiction. I was strung out on meth due to losing my kids. I didn't care anymore. I was just doing drugs, and I've been here for a while, and I'd like to know if I could go to ASAP while I'm still on parole.
Okay. Well, I'm not sure about ASAP, Mr. Taylor, but I will state for the record that at this point, you are 60 years old and you do have 6 prior felonies and 16 prior misdemeanors, and you were on parole at the time of this offense, which occurred back in August of last year, where police were dispatched and you were on parole, therefore you were searched and you were in possession of methamphetamine, which resulted in the conviction that you're here to be sentenced for today. Your guidelines are 10 to 23 months, but you did have a sentence agreement that you be sentenced to guidelines at 0 to 17 at worst, and I am going to go along with that plea agreement. Although usually if people have sentencing guidelines of 0 to 17, they would be placed on a probationary sentence. I don't believe that to be appropriate given the fact that you were already on parole at the time of this offense. So instead, I am going to sentence you within those guidelines to 6 months in the Kenton County Correctional Facility with credit for 2 days already served. There's also a $68 state minimum cost, $130 crime victim rights assessment, and $1,000 in court costs that you'll be responsible for. And Mr. Taylor, you do have 42 days to appeal your sentence. If you'd like a court-appointed attorney to represent you in an appeal, you have 42 days to make that request. That's what the green sheet is for that the deputy will give you. All right, thank you. Mr. Hunting, are you ready on Williams?
We are,
So this will be 2411195 FH People versus Charles Williams Jr. and Mr. Hunting is here on behalf of the defendant. Mr. Heckman's here on behalf of the people. And Sir, could you verify your date of birth, please?
Yes, 10/1/1997.
Thank you. Mr. Heckman, do you have any additions or corrections to make to the pre-sentence report?
I know, Your Honor.
Do you, Mr. Hunting?
I do not. I spoke to Mr. Williams. I don't believe he is in either.
Do you agree, Mr. Williams? And Mr. Heckman, did you have a statement on behalf of the people?
I know, Your Honor.
Statement, Mr. Hunting?
Your Honor, I came in late to this case after there was a conflict with the defender's office, so I've not had the opportunity to get to know Mr. Williams very well, but the initial contacts that I've had with him, he's accepted responsibility for his actions. I watched the video that I guess leads to him standing next to me here today, and there's no question he was severely intoxicated at the time that there was a police call to the house on a domestic disturbance. And he did wrestle and struggle and did not follow the commands of the police officers when they were trying to remove him from the home. So this charge and this conviction is appropriate, and I think Mr. Williams would tell you the same thing. His criminal history, while it exists, it is principally stemming from what I think he would acknowledge as an alcohol and substance abuse problem. I think the recommendation is fair probation and frankly maybe a lengthy term of probation to allow him to get the help and treatment that he needs while being monitored by the probation department is an appropriate resolution, and we'd ask that you follow it.
Great, and Mr. Williams, did you have anything that you'd like to say before I sentence you?
No, ma'am.
Okay. I did get a report from court services as well that just stated that he's been compliant except for failing to appear for a drug test last month.
That's my understanding, Your Honor. No contact, no issues other than the failing to test.
Okay. So, Mr. Williams, at this point, you're 27 years old. You do have 2 prior felonies and 12 prior misdemeanors, and this particular incident occurred back in October of last year, where you were hiding inside of a home, apparently, where the police were sent to, and then when you were removed from the closet you were hiding in, you wound up resisting the officers, which resulted in the conviction that you're here for today. Your guidelines are 0 to 11 months. What I'm gonna do is sentence you to 7 days jail, credit for 7 days already served. I'm also placing you on probation for 2 years. Because I am placing you on probation, you may be eligible for early discharge from probation after you've completed 1/2 of the original probationary period. And if your probation agent does not notify the court, then you may do so using an approved court form. I'm also ordering a $68 state minimum cost, $130 crime victim rights assessment, $1,000 in court costs, and there are supervision fees that go along with being on probation. And Mr. Williams, you do have 42 days to appeal your sentence. If you'd like a court-appointed attorney to represent you in an appeal, you have 42 days to make that request. That's what that green sheet is for. And what you'll need to do is go from here over to 82 Ionia so that you can get set up on probation. Okay, thank you. Good luck.
Thank you, Your Honor.
Mr. Simpkins, are you ready on Scott?
Yes, Your Honor. Good morning.
Good morning. So this will be 2402887 FH, People versus Irvin, Scott, and is it Scott or Scope?
It's Scope.
Scope. Okay, and Mr. Simpkins is here on behalf of the defendant. Mr. Heckman is here on behalf of the people. And if you could verify your date of birth, please.
1/14/1968.
Thank you. Mr. Heckman, do you have any additions or corrections to make to the pre-sentence report?
No, Your Honor.
Do you, Mr. Simpkins?
We just have one, Your Honor. We noticed that on page 1, under the evaluation plan, it states before the court stands 54-year-old Irvin Scope. He's actually 57. The very front of this report has his correct age, but that one portion does not. That is our correction, excuse me.
All right. And so I've made that correction. Any others?
No, Your Honor.
Do you agree, Mr. Scope?
I thought there was one more about, I don't know what page it is, but there was one where it said I was arrested when I was 31, I was actually 24. It said last arrest date 31.
You don't know which
You don't know what
page?
page it's on.
Page 1 of the basic information report, Your Honor.
Yeah, age of first arrest.
And you said it should say,
Right, I was 24. When I was 31, I was married to my wife. I haven't done anything bad since I was like just out of teenager. That was the last thing I did that was stupid until now.
and any objection to changing that, Mr. Heckman?
No.
Okay, so I made that correction as well. And any others, Mr. Scope?
Not that I noticed.
Okay, and Mr. Heckman, did you have a statement on behalf of the people?
No, Your Honor.
And Mr. Simpkins' statement?
Briefly, Your Honor, I'm assuming the court received the materials I sent in earlier this week.
Yes, I'm sorry I didn't mention
that's
that. I
okay.
did, get letters from Mr. Scope's family, sex offender risk assessment, and from his counsel.
All right, thank you, Your Honor. We didn't send those in last week because we didn't receive the pre-sentence report until Monday, so. That said, Your Honor, I think most of my comments are contained within that, the materials that I've submitted. However, I will say that he is struggling to find a job right now due to the nature of this conviction, so, assuming that's part of probation, he will certainly work with probation, and I'll help him. I know there are some employers that do employ people in his position, so we'll make sure that he complies with any orders of probation that the court's going to impose. I don't think jail is necessary in this situation. Your Honor, he's 57 years old. Really no prior criminal history to speak of, other than whatever happened when he was 24, which isn't clear because it was so old. That said, Your Honor, I think a minimal term of probation would be appropriate in this case.
All right, and Mr. Scope, did you have anything that you'd like to say before I sentence you?
I gave you the 3 letters of what led up to what I had done over the past 10 years that led up to why I was doing it. Other than that, I know I have a real addiction to pornography. So I've been working with Dr. David Udelfesh, which is a sexual awareness group. And I do that every Thursday. And they got me set up with locking all my computers out. So I only have access to a computer when my wife or kid are in the room and the computer is unlocked because it's got a password. Also, my phone has Covenant Eyes, so it sends everything to my wife. You know, that any place I serve, it gives her like every 10 seconds she gets screenshots. So I'm being monitored basically. So
Okay.
and I'm trying to be good. I'm trying to be better.
Okay. Mr. Scope, as has already been stated, you are currently 57 years old and you don't have any prior convictions of any kind. In this particular incident is a result of a search warrant that was performed apparently at your home of your computers, and there was child sexually abusive material found on your computer, which resulted in the conviction that you're here to be sentenced for today. Your guidelines are 0 to 6 months. I am going to sentence you within those guidelines, and I do appreciate your comments and letters and you acknowledging that you have an issue with pornography. And there's pornography and then there's child pornography.
I know.
There's a big distinction between the two, and hopefully your addiction doesn't involve the child pornography aspect, but that's why you're here to be sentenced, is because of the fact that there were definitely pornographic images that you were in possession of that involved children. Having said that, what I'm going to do is sentence you to 90 days jail with credit for 2 days already served. I'm suspending the balance of that jail time, and I am placing you on probation for 3 years. Because I am placing you on probation, you may be eligible for early discharge after you've completed 1/2 of that original probationary period, and if your probation agent does not notify the court, then you may do so using an approved court form. There's also a $60 DNA fee, $68 state minimum cost, $130 crime victim rights assessment, and $1,000 in court costs that you'll be responsible for, as well as supervision fees that go along with being on probation. And Mr. Scope, you do have 42 days to appeal your sentence. If you'd like a court-appointed attorney to represent you in an appeal, you have 42 days to make that request. That's what that green paper is for. And what you'll need to do is go from here over to 82 Ionia so that you can get set up on probation.
Judge, I think you have to officially state that SORA registration requirements.
Okay, and yes, and that is true, Mr. Mr. Scope, you are responsible for complying with all Sex Offender Registry Act requirements under the law.
Is that at 82 Ionia 2?
Yeah, and your attorney will talk to you about it, and they will as well, to make sure that you are compliant with that
Okay.
act. Okay?
All right, thank you, Your
Thanks.
Thank you,
Honor.
Your Honor.
Mr. Cordes, are you ready on Moran?
I am, Your Honor.
Okay. So next will be 2311591 FH, People versus Jose Morin. Mr. Cordes is here on behalf of the defendant, and Mr. Heckman is here on behalf of the people. And sir, could you verify your date of birth, please?
Yes.
Date of birth.
Date of birth, 12/12/1953.
Thank you. And Mr. Heckman, do you have any additions or corrections to make to the pre-sentence report?
I know, Your Honor.
Do you, Mr. Cordes?
No additions or corrections. We did note one small objection to the guidelines, number 9. It doesn't change the ultimate guideline, but number of victims is listed as 10 points for 2 victims. I think the testimony that we got through a trial and in the pre-sentence report shows that the second individual was clearly outside of the building and outside of any danger zone, so to speak. So we would ask OV9 be stricken to 0 points, which would make total OV points 40.
Mr. Heckman?
Judge, I would oppose that reduction. The testimony was that this other person who was there did leave the store or was on the way out of the store before the shots were fired, but the danger zone, as it relates to a bullet, is quite a bit further than a baseball or a bat or a fist or something like that. So that person is certainly within the danger zone as a result of the discharge of the defendant's weapon. So I would oppose that reduction.
Mr. Cordes, anything further?
Just simply there was one shot fired, not multiple shots, so we'd stand on that.
Okay. Well, I am going to leave that as scored because I do believe that when you fire a weapon in the way that it was fired, in the direction that it was fired, that it definitely could have struck someone besides the one person that it did strike. And not necessarily the other individual in the store, but I believe there was, the defendant's spouse was in the store, the bullet could have ricocheted and hit her, or someone else that was walking by or coming into the store. So I believe that it could be argued that there was more than one person placed in danger of being struck. So I will respectfully deny the request to amend that offense variable. And any other additions or corrections?
Nothing further.
Do you agree, Mr. Morin?
Yes.
And Mr. Heckman, did you, well, first I'll ask if there's a victim wishing to be heard.
Your Honor, the victim is present. He was here this morning. He is now allowed to come into the courtroom and see Mr. Morin again. In my speaking with him, he indicates that this has had a dramatic impact on his life. He still suffers the after effects of the injuries. Perhaps that might be a very long term, if not lifelong. Indicated that there's at the very least fragments of the bullet still within his body. So we would ask you to impose a sentence that is appropriate given the facts that were elicited both during the proceedings and the rest of this process.
Okay. And did you have any other statement? Is that it, Mr.
That's it, Judge.
Okay. Mr. Cordes' statement?
Thank you, Your Honor. I've been dealing with Mr. Morin and his wife for over 1.5 years on this matter. We've got a court services report indicating there's been no violations, no problem. I think that's perfectly consistent with Mr. Morin and his character. He was 69 years old at the time this happened and had no prior record up to that point. Again, we got through a day's worth of testimony in this trial, and then it was resolved entering a no contest plea. I believe it's a fair resolution. I've submitted letters on behalf of Mr. Morin from his community. Everybody speaks highly of him. looks up to him as he is a valued member of the community and a very helpful member to neighbors. So with that, we would ask the court, if the court is likely to give jail, considering suspending that for successful completion of probation. I know Mr. Morin has his wife, his daughter-in-law, her husband here, who've been here and supporting all along the way. So with that, we would ask the court to sentence as such.
Okay, and I did receive 6 letters in support of Mr. Morin from various people in the community. So I will state that for the record as well. Mr. Morin, did you have anything that you'd like to say before I sentence you?
No.
Okay. Well, sir, at this point, you are 71 years old and you don't have any prior criminal record at all. This particular incident occurred back in September of 2023, where apparently the victim in this case was in your store along with another individual when he decided to steal some property that you had for sale from the store. And instead of calling the police or even trying to tackle him, you instead elected to shoot him in the back as he ran from the store with the items that he stole, which apparently were of nominal value. And also, this particular victim was a child. He was 16 years old. Granted, it probably wasn't the smartest or best thing for him to do to make the decision to grab something and that belonged to you and run out of the store. However, we cannot have store owners just shooting children for stealing things. Taking the law into your own hands is obviously not only ill-advised, but can result in, you could have killed him. He was very significantly injured. He had to have surgery, and apparently he still suffers from the ramifications of your decision to shoot him in the back. Your guidelines for the careless use of a firearm resulting in injury or death are 0 to 9 months. For the aggravated assault, they're not applicable because that is a misdemeanor conviction. What I'm going to do is I am going to, for these counts, is I am going to sentence you to 60 days jail. I do believe that some amount of jail time is appropriate, again, given the decision that you made in this case and the aftermath of that decision. You will receive credit for 1 day already served. I'm also placing you on probation for 2 years. And because I am placing you on probation, you may be eligible for early discharge from probation after you've completed 1/2 of the original probationary period. There's also a $60 DNA fee, $118 state minimum cost, $130 crime victim rights assessment, $1,000 in court costs, and there's supervision fees that go along with being on probation. And Mr. Morin, you do have 42 days to appeal your sentence. If you'd like a court-appointed attorney to represent you in an appeal, you have 42 days to make that request. Also, I did delete the requirement for a community service in this case because of the jail time.
Thank you, Your Honor.
Thank you.
Thank you. And then you have Mr. Young as well.
Yes.
Of course.